Welcome everyone again to the University of New Mexico Law and Mental Health Didactic Series, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. Thank you so much for all of you joining us today. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico in the Department of Psychiatry and Behavioral Sciences. For today's talk, if you have any questions for our presenter, make sure you ask them in the Q&A box, not the chat box, anytime you feel comfortable. But just know we hold those to the end. We try to get to as many as possible. Just forgive us if we can't get to yours. For those of you that are pursuing continuing medical education credits, there will be a sign-in chat in the chat very shortly. For those that are pursuing APA continuing education credits, that will pop up around the last 5 minutes or so of the hour. Make sure that you open that link before you leave the webinar. Make sure you save your certificate after completing the survey, because we don't have records. We are not able to keep copies of those completed surveys. As a heads up, the recording and PowerPoint slides for this talk will be available to you sometime later in the week. And for next week's talk in the series, we'll have Dr. Nikki Colombino, who will be discussing adolescents who engage in harmful sexual behavior. All right, now's the time that we've been waiting for this week. I'd like you to introduce you to today's speaker. We'll be discussing Olmstead versus LC and the application of Americans with Disabilities Act to state psychiatric hospitals. This is Dr. Andrea Avila. Dr. Andrea Avila is a clinical and forensic psychologist working at Oregon State Hospital, as well as in private practice. She also has her JD and is a licensed attorney. Her primary interests are in violence risk assessment for people with serious mental illness, community reintegration for people with serious mental illness, mental health advance directives, and mental health law and policy. I'll also add that if you've ever been to an American Psychology Law Society conference, and particularly if you were at this most recent one in Philadelphia, you have her to thank as a co-organizer and all of the work that goes into rounding our psycholegal mental health professionals together for that conference. Andrea, Dr. Avila, on behalf of the University of New Mexico, can I say we're very excited to have you joining our series and thankful for you sharing your expertise. I will now turn it over to you.
Well, thank you very much for that. And I also want to thank you and your team for putting together this series of presentations. I know it has to be a ton of work. I've loved attending these and learning about so many topics. And it's just such an honor for me to be able to be here and to participate now. So I'm really grateful for that. I also thought it was quite remarkable when I was preparing for this. I was contacted to make sure that my slides were accessible to people with disabilities and compliant with the Rehabilitation Act, which is the precursor to the ADA, which I'm going to be talking about today. So, of course, I absolutely loved seeing that be a part of this process. So not only is the series a tremendous service to the field, it's also to be commended for its commitment to inclusion. So many thanks to you and your team for running this weekly series. But today, I'm going to be talking about parts of my dissertation from a few years ago. And I absolutely repurposed my defense slides and enjoyed a bit of nostalgia in the process. So I decided to leave my alma mater's logo on the project that I did there. And I'm currently at Oregon State Hospital. And before we begin, I want to just take a moment to talk about language. And there's two terms in particular that I'd like to address. The first is the term disability. And I understand that there is debate about the use of the term. And I am a wholehearted believer in the indispensability of using people first language. And I will be using the term disability throughout the presentation, primarily because I'm discussing the Americans with Disabilities Act and the area of disability rights law, and because disability is the term that is used in the lawsuits that I'll be reviewing. The second term I'd like to address is serious mental illness, and it's often abbreviated to SMI. So definitions of SMI are truly only consistent in how greatly they vary from setting to setting. Different statutes, regulations, policies, and procedures, they all seem to have their own way of defining SMI. And there's also variations on the term that can include words like severe and persistent. And some folks reasonably argue that words like severe or persistent should be avoided to expel any connotation possibly antithetical to a recovery orientation, or anything that might suggest that mental illness is intrinsically intractable or unresponsive to treatment. And although I absolutely believe that any attempt to dispel perceptions of mental illness as untreatable is noble, I'd also advise caution in moving the term away from a description of functional impairment, as it can have unintended consequences that should be carefully considered. So a specific example of this will be discussed later in the presentation, but I bring up these issues in language to note from the very beginning of the presentation about how we define and talk about our target populations of a policy or an intervention has a significant effect on everything from who is eligible to receive services, to how funding and resources are allocated, to even the political viability of a proposed policy change. Additionally, the whole reason it is worth parsing out a more serious group of folks within the larger population of people with mental illness is to try and identify and differentiate those with the most significant need for clinical intervention. Further, within the context of disability rights law, the objective would also be to identify people who are most at risk of having their rights violated. So throughout the presentation, I'll refer to serious, severe, persistent mental illness, and this is in no way intended to diminish a focus on a recovery orientation or disability rights advocacy. It is an attempt to ensure that the people who would most benefit from more intensive supportive services are not lost in the larger population of all people with mental illness and left behind to fall through the cracks of the mental health system, as history has shown us repeatedly will absolutely be the outcome if their unique needs are not attended to. So one final note before beginning, my typical presentation style is very interactive. I love to encourage questions and discussions and debate. And unfortunately, this format limits that option significantly. So I've built in a few polls throughout, and I encourage people to be prepared for those and to participate if they're able to do so. The first poll I'm going to launch right now, and it is to ask how familiar participants are with the Olmstead decision and its subsequent enforcement. All right. We still have a few answers rolling in, so I'm going to give people just a moment longer. Awesome. Okay, so it looks like most people are landing in the area of they think they may have heard of Olmstead. So that, and the next most popular one is they're maybe familiar with the general holding of Olmstead. So I am excited to be able to share more about this case with people who may not know as much about it. So the Olmstead decision was decided under the Americans with Disabilities Act. And it's important to note that there are multiple sources of law that can be applied to state psychiatric hospitals and other organizations to enforce the rights of people with disabilities. The ADA is merely one of many. Olmstead was about people with serious mental illness living in a state psychiatric hospital and wanting to transition into the community. Olmstead's ultimate holding was that unjustified segregation of people with disabilities is per se impermissible discrimination under the ADA. So that is to say, it is in and of itself, it is intrinsically discrimination and impermissible under the ADA. So if a clinician and a client believe that community placement is appropriate, the state must have reasonable accommodations in place for the client to be in the community. Now, the phrase reasonable accommodations may sound familiar because it's commonly used in connection with Title I of the ADA, which is in reference to employment. So Title I covers employment and Title II covers public accommodations. While the original focus of the Olmstead case was on people with intellectual disabilities, severe mental illness, or severe personality disorders who were living in psychiatric institutions, Olmstead has been expanded to multiple settings and disabilities, everything from institutional living to who is eligible for orthopedic devices under Medicaid. Basically, anything with a defensible connection to keeping people with disabilities more fully integrated into the community by avoiding preventable hospitalizations or any other form of segregation. Now, hopefully the use of the word segregation in the case holding has tipped you off to this, but the Olmstead case has been referred to as the Brown v. Board of Education for People with Disabilities. And once you take a look at the two cases, the similarities are pretty clear. Brown overturned Plessy v. Ferguson, which had promoted a separate but equal doctrine that allowed segregation on the basis of race. Brown argued that this was inherently discriminatory with adverse effects on the children subjected to it. Olmstead made a similar argument, noting that segregating people with disabilities was discriminatory and harmful. So for those keeping score at home, we've now achieved learning objective number 1. That is the holding of Olmstead and why it is sometimes referred to as the Brown v. Board of Disabilities. So this is going to be time for our second poll. And I'd like to know who you think wrote the Olmstead opinion. Now, no Googling, and these are all Supreme Court justices who were on the court at the time that Olmstead was decided. So I promise no trick questions here. I'm going to give it just a second for people to be able to finish the poll. We have a pretty good participation rate here. All right. I'm happy to share that most people got it correct. The opinion was written by Supreme Court Justice Ruth Bader Ginsburg. Many of you may be familiar with the biopic film On the Basis of Sex, which was about her life, or just generally familiar with her legal legacy of addressing sex-based discrimination, first as an attorney and later as a Supreme Court justice. However, people tend to be less familiar with her role in addressing discrimination on the basis of disability. All right, we're going to do another poll now as well. I'd just like to get a feel for folks in the audience what impact the Olmstead decision has had on their work or might have on their work. The very first response was, look, lady, I'm here for the free CEs. So I can appreciate that, absolutely. But just to get an idea about how people might be impacted by this decision and its subsequent enforcement. So it looks like most people work in a setting relevant to Olmstead enforcement or are interested in disability rights or advocacy in general, with a smaller percentage of people having personal experience with policy changes or litigation directly related to Olmstead. Oh yes, and I spent my area of research, even though Olmstead was broadly applicable, looking specifically at people with SMI who are transitioning out of state psychiatric hospitals. Okay, so Olmstead arose from the situation of two plaintiffs in Georgia. And I like to talk a little bit about the plaintiffs whenever I have time when discussing these cases, just so people can hear the stories of the real people behind these, landmark cases that happened. But the first plaintiff, who's identified by the initials LC, she was diagnosed with schizophrenia and voluntarily admitted to Georgia Regional Hospital, or GRH, in Atlanta in May of 1992. A year later, her treatment team determined she was sufficiently improved to warrant treatment in a state-run, community-based treatment program. However, the state failed to actually move her into a community-based treatment program for nearly 3 more years until February of 1996. There's a second plaintiff involved in the case who's identified by the initials EW. She was also voluntarily admitted to GRH with a prior diagnosis of a personality disorder. She arrived in February of 1995, and 1 month later, the hospital attempted to discharge her to a homeless shelter. This attempt was stopped short after an attorney filed an administrative complaint. Her treatment team then later determined that she was also sufficiently improved to move into a state-run community-based treatment program within about a year after that. However, the state also failed to actually move her into a community-based treatment program for over a year, and it was ultimately after the trial court in this case issued its judgment in 1997. So the lawsuit was initially filed in May of 1995. LC was the first plaintiff, and she alleged that her continued institutionalization against her will and the advisement of her treatment team violated, among other things, Title II of the ADA. Her requested remedies were access to the community-based treatment program and, quote, treatment with the ultimate goal of integrating her into the mainstream of society. So EW soon joined with matching allegations of requests. Now, there was some action at the district court and appellate court level, but unfortunately, we don't have time to go into the details. In fact, in all of the cases I'm going to discuss today, there's a tremendous amount of back and forth as courts and judges and plaintiffs and defendants all argue with each other about how to fairly implement both the ADA and the Olmstead decision. And there's this really beautiful nuance to the arguments as they go back and forth. And the last slide has the list of all the cases that I'm going to talk about in the presentation. So I encourage you to read the cases and see the different types of arguments and how they progress over time, if this is an area of interest to you. But 22 states and the territory of Guam all formally requested for the Supreme Court to hear the case, so they did. Now, to fully understand the impact of the ADA and Olmstead on state psychiatric hospitals, it's important to have a little bit of historical context. And I know that as soon as I said historical context, everyone took that as their cue to zone out until the CE survey pops up at the end, and that's fair. I promise to try to make this as quick and painless as possible. I just want to give a few historical details to help make the rest of the presentation make sense. But we are going to start at the beginning, although I promise to move quickly. So the next poll is going to ask you what your estimate is of when the first psychiatric hospital opened in the United States. I really appreciate the response rate. Lots of people are participating. So thank you for that. We'll give it just a moment as a few more responses seem to be coming in. All right. So most people were guessing here in the sort of middle range options. The first psychiatric hospital opened in 1752, about 24 years before the Declaration of Independence was signed, and it was established by the Quakers. Approximately 20 years later, a second facility opened in Williamsburg, Virginia, which is currently known as Eastern State Hospital. So we had 2 psychiatric hospitals before we had even declared our independence as a nation, arguably making mental health treatment a core American value. And by the start of the 20th century, there were around 150,000 people in state psychiatric hospitals. Now, this number swelled to over 500,000 by 1950, which is a growth rate of nearly twice that of the general population in the United States. And the historical apex of the state psychiatric hospital census happened in 1955 and is estimated to be at 559,000 people. Now, the 50s and 60s saw a lot of changes, including the advent of many psychopharmaceuticals, And there's also this whole fascinating history about how the military and the Veterans Administration, as well as legislation to support military members, drove advances in psychology and mental health treatment. But unfortunately, that's also beyond the scope of this presentation. But as I'm sure as everyone is aware, the 1950s, most importantly for mental health history, saw the advent of deinstitutionalization. And I swear to you, I am repeating information from your first year of graduate school for a reason. I want to highlight some specific aspects of deinstitutionalization that provide important parallels to the ADA and to Olmstead. Now, when deinstitutionalization began, it was intended to move people out of the state psychiatric hospitals, which had begun to be seen as inhumane and ineffective, and into the community. Transferring people from the hospitals and into the community was seen as a moral imperative and an urgent need, an axiomatic method of improving the quality of life and treatment outcomes of people with SMI. Consequently, deinstitutionalization was not preceded by empirical testing of its assumptions, and mistakes were made in the implementation of exceedingly well-intentioned national policy on mental health. So the deinstitutionalization movement was wildly successful at simply decreasing the number of people hospitalized from approximately 559,000 people in 1955 to less than 50,000 people in 2003. However, most professionals agree it was implemented without adequate safeguards to ensure access to appropriate community services, such as forcing funding to follow people from the hospitals into the community. Subsequently, many people were shifted into assisted living facilities or nursing facilities, became homeless, or became participants in the trend of prisons and jails housing increasingly high percentages of people with mental illness. While it's unlikely deinstitutionalization directly caused those issues, the lack of comprehensive community-based services to support and bolster those coming out of long-term institutions has certainly created obstacles to community integration among those who needed the most support. Unfortunately, to this day, comprehensive community-based services continue to be lacking, particularly for those with SMI. We're going to do another poll here. This estimate is a little old at this point, but in the modern day, what percentage of people with SMI are estimated to not be receiving adequate care in the community? Okay, the number seems to stabilize there. So most people are guessing around 72 or 85%. It's estimated that 85% of people with SMI are not receiving adequate treatment in the community. So then enter the Community Mental Health Act, which was a vision of President John F. Kennedy's to create and fund community mental health centers. And this act was signed in 1963. The initial goal was for people coming out of the institutions to receive wraparound care from these centers in the community, including outpatient therapy, short-term inpatient treatment, partial hospitalization, and crisis services. Sounds great, right? Unfortunately, the legislation that actually reached President Kennedy's desk was a shadow of the initial vision. It included funding for the literal buildings only, no staff. And as we all learned in graduate school, true recovery and well-being occurs in empty buildings with no people. Then, truly unfortunately, about a month after having signed the Community Mental Health Act, President Kennedy was assassinated. Fortunately, the Johnson administration was able to pass amendments to the Community Mental Health Act and begin providing funding for the Community Mental Health Center, and grants began to be administered within a few years after that. However, and as you may anticipate by this point in the history lesson, what I'm going to say next is also kind of a bummer. The community mental health center grants had no requirement to coordinate with the existing state psychiatric hospitals or the state government, leading to disjointed provision of services and lack of coordinated care. CMHCs were also ideally supposed to transition away from federal funding, but the assumption that funds would follow individuals from the state hospital into the community was proven false. There's also a lot going on at the same time with the Medicare and the Medicaid programs, but all of that is too much to cover here. So here's the bottom line. The Community Mental Health Act required that the number of state psychiatric hospital beds be cut in half within 20 years. And this was a requirement that was met well before the deadline. The state hospital census overall was cut by about 75% between 1955 and 1980. And it's been estimated that in order to successfully serve that population in the community, there should have been more than 3 times as many community mental health centers as there actually were. Even worse for people with SMI, many community mental health centers began serving segments of the population who had been previously untreated, which is wonderful for the larger population of people with mental illness, but they weren't identifying and prioritizing the people who had typically been receiving services from the state psychiatric hospital. So earlier, whenever I talked about definitions and defining the target population for interventions, although we certainly never want to be pejorative, we do need to be intentional and clear about who we intend to serve, because it's never those with the most power and privilege who are accidentally left behind with major policy changes. So overall, while people were exiting the state hospitals at high rates, the national rate for people in all institutional settings did not fluctuate, which, among other things, suggests trans-institutionalization, or the movement of people from one type of institution to another. Now, that historical context ended up being more than a few minutes, and it was kind of a bummer. So I am sorry about that, but we are still moving towards the 3 CEs. So that is the good news. So that historical summary leaves us in the early 80s, about 20 years after the passage of the Community Mental Health Act. The ADA was then passed in 1990, and Olmstead was decided in 1999. Now, Justice Ginsburg's opinion was divided into 5 parts. Only the first 4 parts received the necessary majority votes, but 6 justices overall concurred in the judgment. And in addition to that, there's multiple concurrences and dissents. And so even among the folks who agreed with each other, there's some disagreement. And it really highlights that this case is nuanced and complex, and the way to implement it is complicated and people don't agree on it. And it also sets the stage for a lot of subsequent confusion. Now, there's a lot in the first 3 parts about interpreting the ADA in light of prior legislation like the Rehabilitation Act and talking about congressional findings. I'm not going to bore you with all of that. I'm just going to very quickly point out 2 parts of the discussion that are relevant to the conversation between the justices in the Olmstead opinion. So the first part is in the ADA, in Title I and Title II, they both have a general statement barring, quote, discrimination. However, in Title I, that general statement is immediately followed by a subsection which details that the term discrimination is intended to include, and I quote, limiting, segregating, or classifying a job applicant or employee in a way that adversely affects their opportunities or status. It goes on to list several ways in which an employer could potentially discriminate against a job applicant or employee, and it's not brief. Title II only has the general statement barring discrimination, not the follow-up subsection with all of the additional information and explanation. The second point that I'll note from these first 3 parts is that Justice Ginsburg took notice that the U.S. Department of Justice is the agency responsible for enforcing the ADA. And she further noted that the Department of Justice clearly indicated that integration is a requirement of the ADA in its mandate to eliminate discrimination against people with disabilities. All right, so now we can get to the more interesting parts of the opinion. The fourth part of the opinion addressed the question of whether there was discrimination in this case, while the fifth and final part asked if there was discrimination, are the requested accommodations reasonable? Now, a modification is not considered reasonable if it would fundamentally alter the nature of the service, program, or activity. So it's important to note here that the initial allegation is discrimination. And normally, when a plaintiff proves an allegation against a defendant in a lawsuit, they win. However, in some cases, including this one, defendants can provide an affirmative defense. So in this case, they can essentially say, yes, there was unjustified segregation, aka discrimination. But in order to change that, we would have had to have fundamentally altered the nature of the services provided. So the requested accommodations are not reasonable. 5 justices voted there was discrimination, and all the discussion between the justices centers on whether or not there was discrimination in the case. But when it came to the last part of the opinion, the part about the fundamental alterations defense, only 4 justices joined in that opinion. And then no one talked about it anymore. No one argued with Justice Ginsburg's opinion or offered an alternative. The 2 that did not vote for that part of the opinion but concurred in the overall judgment did so on a completely separate basis, not related to the actual content of the fundamental alterations test. So overall, this is the part of the case that got the least amount of attention from the Supreme Court. And spoiler alert, 24 years of litigation that have since followed have centered almost exclusively on this part of the opinion. So I'm going to talk a little bit about this part of the opinion now, because it basically gets ignored once we get into the discussion between the justices. Essentially, up to this point, there had been 2 primary arguments about whether requested accommodations were reasonable or a fundamental alteration. So as a reminder, the requested accommodations in this case are people with SMI being more quickly integrated into the community when both the treatment team and the client think it's a good idea. The first argument is essentially a couple of people in the whole state budget could not possibly fundamentally alter the provision of services, and community services are cheaper anyway. This argument would set it up so that the government almost always loses. The opposite of that argument on the other extreme is the government saying, we've maxed out our resources. We don't have any more money. We don't have any more resources to try and make these changes. Therefore, any change would be unreasonable and a fundamental alteration. And that argument would set it up so the government almost always wins. Now, Justice Ginsburg cut a middle path between these arguments. And she says that the fundamental alteration test should permit a state to successfully defend on the grounds that the state has an obligation to care for a large and diverse population of people with disabilities, and that care would be inequitably administered if they were required to provide immediate relocation for the plaintiffs. So essentially, she was allowing states to acknowledge the full picture of their mental health system when arguing that they're being faced with a fundamental alteration to the way that their mental health system functions. She also noted that while the plaintiffs were correct in arguing that the state had a lower cost per client when providing treatment in a community-based program as compared to in an institution, she noted that such a simple comparison overlooks costs the state cannot avoid, such as increasing overall expenses by funding community placements without being able to take advantage of the savings associated with the closure of institutions. Now, I highlight these 2 quotes from Justice Ginsburg because in her writing, she insisted that the ADA does not require states to close all institutions and place patients in need of close care at risk, nor does it require the state to discharge consumers to any other setting like a homeless shelter. She noted that one method that a state could use to show that they were maintaining a range of facilities and administering services with an even hand would be to develop and implement a plan for moving willing individuals clinically determined to be appropriate for community placement into less restrictive settings. She went on to say that having a waiting list for these community placements was not prohibited, provided the waiting list moved at a, quote, reasonable pace and was not influenced by a motivation to keep all institutional beds full. Now, I'm going to talk about the dissenting opinion first because I think the concurring opinions make more sense after you've heard the dissent. So the dissenting opinion written by Justice Thomas argued there's no discrimination in this case because the plaintiffs were not denied community placement on account of their disabilities. And there's no comparison group of similarly situated individuals without a disability who received preferential treatment. There's only some people with disabilities receiving treatment in the community, while some remain in an institution. The dissent further argued this court has never endorsed an interpretation of the term discrimination that encompassed disparate treatment among members of the same protected class. The dissent also rejected the majority's contention that Congress had intended to broaden the definition of discrimination to include unjustified segregation. And they specifically cited back to those differences that I talked about between Title I and Title II, with Title I having that additional explanation section and Title II not having that. So they said because Title II didn't have that, Congress didn't mean for discrimination to include unjustified segregation as applied to Title II. The dissent did not speak to the Department of Justice's role in interpretation of the ADA. So then Justice Ginsburg accounted for these things in her majority opinion. She gave back three main points. First, she cited to the section of the ADA that outlined congressional intent for the statute for the ADA. And she noted that the ADA had escalated in its language from prior legislation like the Rehabilitation Act, and that in its findings, it had discussed how institutionalization is an area of persistent discrimination. And Justice Ginsburg also noted that the Department of Justice, in its interpretation, had clearly indicated that integration was a requirement of the ADA in its mandate to eliminate discrimination against people with disabilities. Second, Justice Ginsburg argued there is a similarly situated group receiving preferential treatment, and that's people with physical disabilities. While people with mental health related disabilities are essentially being required to receive treatment in an institution, people with physical disabilities are often able to receive treatment in the community. And the court noted this difference in treatment is particularly troubling in light of how comprehensively living in an institution reduces one's ability to participate in social relationships, professional development, and community life more generally. Finally, in what might be my favorite Supreme Court quote of all time, she responded to the dissent's assertion that discrimination had never been shown by demonstrating differential treatment among members of the same protected class by saying the dissent is incorrect as a matter of precedent and logic. And there's citations to two cases to support that. The first is a case on age discrimination, which held that employees over 40 years old are protected even if the person who was favored over them is also over 40, provided the plaintiff was discriminated against based on age. The second citation is to a case that held there could be discrimination against Black women, even in the context of no discrimination against Black men or white women. Justice Stevens wrote a concurrence, and he essentially didn't vote with the fundamental alterations test based on a technicality. If you recall, I said in the procedural history, there was a lot of back and forth before this case was heard by the Supreme Court. And essentially Justice Stevens said that back and forth should have had more of an opportunity to play out. The Supreme Court took the case too early. Justice Kennedy also wrote a concurrence, and he began by noting that despite remarkable advances in treatment science and advocacy by professionals, people with SMI continued to be treated at inadequate rates. And that was due at least partially to a lack of consistent public resources and historic mistreatment. He also briefly noted that while deinstitutionalization was executed with, quote, benign objectives and was beneficial for many people, it was also, and I quote here, a psychiatric Titanic for many others. He opined that in this case, there wasn't discrimination per se, but there could be discrimination if the plaintiffs could prove that there was differential treatment between people with physical and mental health disabilities. So again, for those of you keeping score at home, that was the second of our 3 learning objectives, being able to talk about Olmstead's main discussion points on both sides. So what now? Olmstead was decided in 1999, and then several states proactively took action to develop what became known as Olmstead plans. By 2004, 29 states, including Georgia, the state where the case originally arose, had developed Olmstead plans. However, as United States Supreme Court decisions tend to do, the court had left open several important questions about precise implementation in its decision, including how to define a reasonable pace for waiting lists and exactly what outcomes would indicate that a state has an effective plan. So naming a plan Olmstead doesn't ensure that it complies with the court's ambiguous requirements, leaving even well-intentioned states unsure if their plans were sufficient. Predictably, lawsuits ensued. Initially, those lawsuits were typically filed by advocacy agencies or classes of plaintiffs. However, in 2009, the Civil Rights Division of the United States Department of Justice started enforcing Olmstead by suing states with inadequate plans. So all of these different routes of implementing the Olmstead decision led to a great deal of variability in how Olmstead was enforced. So to learn more about how courts were enforcing Olmstead, I used Westlaw headnotes. Now, Westlaw is a legal research database that includes all kinds of legal information. And it uses what are called headnotes, which is basically an indexing system for different points or arguments that people can make in the opinion, either in the majority or in the dissent. So using this indexing system, I looked at 8 of the headnotes from Olmstead that were relevant and looked for appellate and district court cases that were citing back to Olmstead using those headnotes, and specifically looked for cases that were either involving or were applicable to people with SMI transitioning into more integrated settings. And since the Department of Justice has been involved in Olmstead enforcement, I also looked at their litigation to identify situations that were large enough to require statewide policy changes, since that was analogous to the other cases that I was finding, and either involved or were applicable to people with SMI transitioning to more integrated settings. So we're going to do another poll here. Out of my research, I found 10 states ultimately that had a case that was relevant, and only one of them was found to not be discriminating at all. The other ones all had to rely on the fundamental alterations or the affirmative defense. So which state do you guess out of these 10 was the one that was found to not be discriminating? Okay. We have a few more responses still coming in, so I'm going to give it just a moment longer. All right, I'm going to end it there and share the results. So it looks like the top contender is California, with a next tie being New Hampshire, and then Minnesota and Washington, as well as Delaware being top contenders. So remember what you chose, and we'll reveal it here in just a second. So the relevant case that arose, oops, sorry about that. The relevant case that arose in the Third Circuit began in 2001 and came from the situation initially of 4 adult plaintiffs who were hospitalized at Norristown State Hospital in Pennsylvania. One plaintiff had been recommended for discharge for almost 4 years, while another had been recommended for discharge for almost 2 or over 2. The court noted that the professionals at the hospital tended to be unaware of services available in the community, and even when they were, potential discharges were only evaluated for community readiness based on however they fit, based on the capacity of the individual to fit however awkwardly into existing programs, as opposed to considering their community readiness had more comprehensive and inclusive community services been available. I'm also noticing the time, so I'm going to try to move through these kind of quickly so that we have some time for questions. Of note, this case grew as it went through the system from more than 4 plaintiffs to 300 people. It ended up including all individuals hospitalized at that hospital for non-forensic reasons. At trial, the professionals from the hospital admitted that at any given time, about 1/3 of the plaintiff class was clinically stable and ready for discharge. So that would have been 100 patients at any given time. The discrimination allegation in this case was uncontested. Everyone agreed that the state hospital had engaged in impermissible segregation. The only question was whether the changes to the system that were requested would be reasonable modifications or a fundamental alteration. Ultimately, the Third Circuit required that states must have written plans with specific and measurable goals of fewer state psychiatric hospital beds by particular dates. The court seemed to view bright line markers such as lower bed numbers by certain dates as crucial elements of accountability. So the Third Circuit also commented on Pennsylvania's, quote, strong commitment in the past to deinstitutionalization, as it had decreased the hospital population from 40,000 to 3,000 in the 50 years preceding. So overall, the court required a specific date of discharge for an approximate number of people, along with discharge eligibility requirements and a general description of the collaboration required between the hospital and the community. In the Ninth Circuit, there were 2 cases that came up, one in California and one in Washington. And in both cases, the challenges were related to the Medicaid waiver program. Essentially, the plaintiffs were contesting that the state should apply for more waiver programs to be able to move people into community program slots faster. In both cases, the Ninth Circuit found that the state was enthusiastically using the existing program and was also proactively trying to grow other outpatient service options, even in the face of budget cuts for other programs. The court also appreciated the appropriateness of personalized assessments for individuals to evaluate readiness for discharge. And the Ninth Circuit ultimately said that it would not tinker with a state's comprehensive, effectively working plan, especially if its opportunities for community treatment were continually increasing in both budget and real number of program slots. It consistently used all available treatment opportunities in the community, and it showed evidence of a continuing trend of deinstitutionalization. Although there was some variation across states, the Department of Justice took a relatively consistent approach in their settlement agreements. They typically required specific infrastructure and mental health system development rather than a focus on census numbers in the state hospital or funding shifts. Services developed included mobile crisis response units and sometimes crisis centers and hotlines, sometimes education for police and judges, often assertive community treatment teams, case management, respite and integrated supported housing, and a quality insurance mechanism. There were no requirements to show a specific reduction in the number of state psychiatric hospital beds by a particular time, but the focus was more on developing the services in the community and developing a process by which to move people into the community. There was an overarching goal of decreased deinstitutionalization in favor of increased integration, but there's no specifics stated. In Minnesota in 2009, a group of individuals with developmental disabilities sued the state of Minnesota for inappropriate use of restraint and seclusion. In 2011, the parties jointly submitted a settlement agreement, which was accepted by the court with the condition of ongoing supervision of the court. The settlement agreement at that time included all people with disabilities, which stretched far beyond the original plaintiff group. Now, one of the court's requirements for the settlement agreement was that the state develop and implement within 18 months a comprehensive Olmstead plan to improve the lives of individuals with disabilities. Now, it took 3 years and 4 rejected plans before the court finally accepted the proposed plan in 2015. And the court looked to 3 specific factors as to what made the plan acceptable. First, the revised plan had concrete, measurable goals with specific timelines and baseline data and annual improvement targets. Second, the goals of the revised plan were pertinent to the Olmstead mission and clearly indicated which agencies were responsible for each goal. Finally, the final plan also included an annual review and formal amendment process to ensure it could be a dynamic roadmap that could be responsive to newly identified needs while maintaining a commitment to the original goals. Now, the plan included a number of service areas to be developed, including transition services, housing services, employment, opportunities for lifelong learning and education, transportation, healthcare and healthy living, positive supports, crisis services, and community engagement. So finally, here's the winner of our poll. It was Florida. Florida was the only state found to have not been discriminating in the process of the litigation. Florida had a class of currently or formerly hospitalized individuals who brought suit against the state psychiatric hospital, alleging violations of the US Constitution, the ADA, and the Civil Rights of Institutionalized Persons Act, or CRIPA. The majority of the plaintiffs were adults with SMI who were civilly committed at the hospital. And every month at the hospital, approximately 30 people were admitted and 30 people were discharged. After a month-long trial, the district court found in favor of the defendants on all charges. They held that the plaintiffs did not prove that the hospital violated the ADA by failing to place clients in the most integrated setting appropriate given their clinical needs. The court found that the hospital began preparing for discharge at admission, and treatment and discharge planning began at admission simultaneously and were updated regularly and involved communication with people in the community who would support the individual upon discharge. Usually people were only waiting 30 to 60 days to be discharged once they were found eligible, and that was typically for the coordination of services. Second, the court found that the options for community placement were diverse and met a wide range of patient needs, and that once placed in the community, people were typically successful and able to remain in the community. So here are some general recommendations, but I'd also like to leave you with a few thoughts about how Olmstead has been being enforced. First, much of the litigation around Olmstead has failed to distinguish between people with SMI and people with other types of disabilities. And this is problematic. Disability policy cannot be effective if it's approached with a monolithic mentality. So again, I'll draw your attention to the discussion of terms and population definitions from the beginning and how important it is to define a target population. But implementing Olmstead effectively for people with serious mental illness should be done differently than for people with other types of disabilities due to differences in clinical needs. So in particular, SMI tends to be chronic and episodic with a reserved place in the treatment continuum for recovery-oriented hospitalization services, either short or long-term, to support people through first episodes or relapses and back into the community. However, for some states, the policies or plans put forward in response to Olmstead seem to be merely extensions of deinstitutionalization by requiring primarily or only long-term hospitalization bed reduction without reflection or critique of the ways in which that might be problematic. And this is explicitly in spite of the writings of Justice Ginsburg and Kennedy, who cautioned against such approaches. While all consumers are negatively impacted by insufficient funding for a variety of treatment options, if the courts interpret Olmstead to require primarily or only a decrease in available hospital beds, this disparately impacts the treatment of people with severe and persistent mental illness, for whom the lack of a continuum of appropriate recovery-oriented treatment services could mean high utilization of crisis services, homelessness, or even incarceration. Here's a few words about Olmstead, basically saying it was important, but its final legacy will depend on the effectiveness with which it is implemented. Here are the case names as promised. They're available in the slides. And here is my contact information if people have questions. Some of what I presented today was published in a paper in Psychological Services last year. And so there's more information available there, and hopefully there will be some more forthcoming publications on this line of research. But thank you very much for your attention, and I'm sorry for going a little bit long, but I hope we still have some time for questions.
Well, we certainly do. And thank you, Andrea, for that engaging talk and use of polls. And I believe I'm allowed to say this as someone that was born and raised in Florida. That was not my guess, but thank you for the thorough overview here. It seems like we've got a lot of questions coming in. And again, if you have additional questions for our presenter, you can put them in the Q&A box. I see some early ones that are, I guess, a little bit more foundational to the decision itself. So I thought I would throw one or two of those your way first. Somebody asked if you know how the plaintiffs in Olmstead were able to retain attorneys. Did advocacy groups find them? Our state hospital patients rarely have the wherewithal to get an attorney for themselves. More of the logistics of having representation for such a monumental case.
That is such a good question. And unfortunately, I don't know that off the top of my head from the Olmstead case. There's a tremendous amount of information about Olmstead available on the internet, and that information may be out there, but I don't know how they were able to retain attorneys.
Sure. And then somebody wanted to clarify that, had a clarification that in APA's guidelines for assessment and intervention with persons with disabilities, they reference an Olmstead Act of 1999. And so they wanted to clarify, aside from Olmstead versus LC, is there such a thing as a separate Olmstead Act?
That's a great question. And if there is, I haven't heard of it. I may try to look into that a little bit more. I appreciate the citation back to where they found that reference, so I can go look at it. But as far as I know, that no.
Thank you. Somebody asked that Olmstead/mental health reform appears to have been geared more toward mild to moderate impairment. It has been a nightmare for, as they call, the sickest of the sick. And we're just saying, do others feel this way? And getting your thoughts if you felt that way.
Sure. Let me see if here's two. Oh, I think that this question kind of speaks to one of the points that I was trying to make, especially whenever we look at how the Community Mental Health Centers Act was not able to serve the population that it was sort of intended to, right? It was intended to serve this population that was coming out of the state psychiatric hospital, but unfortunately, that's not really how it ended up working. It ended up serving other folks in the community who were previously not receiving services, which it's great for everyone to have access to services. But one of the points that I am trying to make is that sometimes whenever we make these big shifts in national mental health policy, we're not considering how our most vulnerable populations can be negatively impacted by them, or sometimes left behind, especially because it's hard for them to gain access to advocates. As the first question noted, it's hard for them to gain access to attorneys who can file lawsuits and things like that.
Thank you. Can you comment on the iatrogenic effects, including deaths upon placement in the community, primarily in low functioning intellectual disability group? And then also, what about choice? Individuals displaced who, along with their families, wanted to remain in the hospital?
So I think those are wonderful questions. And obviously, the goal would be for people who are able to move into the community to be able to experience a tremendous amount of success and to not have negative effects. And I think that that's going to depend a lot on the services that are available to them and their readiness for discharge at the time that transition happens. I love that this question brought up choice. So one of the things that I didn't have as much time to get into in this presentation, but that is important to look at the different ways that Olmstead is being enforced, is whether or not consumers have choice in how they're able to transition. And in some places, they did a better job of that than others. So in places where there's a high priority on moving people out of the state psychiatric hospital and into the community by set dates without a lot of variability around that or flexibility around that, it would lead to predictably some people not having as much choice about being moved out of the state hospital or into settings that they're ready for. And in other places like Minnesota, there was a great emphasis on consumer input into the development of community resources, and then also in consumer choice in how they wanted to proceed forward. So I think as people are looking at the ways that Olmstead is enforced in different places, it's really important to consider whether or not people are being adequately supported as they're being transitioned, whether or not we're empowering people to make choices about their own healthcare as they're transitioning or not, depending on what their choice is, and to consider how more flexibility in the implementation of Olmstead would be more likely to meet those outcomes rather than something that's rigid and just focused on reducing beds in the state hospital.
Thank you for that. Another person asked if you noticed a pattern of preferential treatment or case resolution for states that had governors of the same political party as the president at the time.
Ooh, that's such an interesting question. I didn't look at that or attend to that, but that's a very interesting question. And unfortunately, I mean, there's just so few cases that speak to this particular population. Like if you go and look at Olmstead's implementation, there are just like thousands of cases, but it's because it's so broadly applicable. Whenever you look at this particular population, which is where the Olmstead case originated, there's just so few clear cases talking about how to enforce it and how to implement it. But unfortunately, mental health policy is always sort of political in its nature. And so I'm sure that there's probably some patterns there that I haven't detected, but that would be a wonderful empirical question to investigate.
Absolutely. Wink, wink to all the trainees out there.
Yes.
And then one broader question that we can wrap up with here is how can we help advocate for more community resources for the severely mentally ill population, especially for patients who also have substance use disorder?
That is such a good question. And the first thing that comes to mind is, you know, as you're reading these cases, a lot of them talk about how state budgets are put together and how those budgets allocate resources to different programs. And so I think people need to the extent that they can, educate themselves on how budgets are set in their own state and in their own systems, and find out as much as they can about how those programs are funded and resourced, and then be loud in advocating for resources for more vulnerable populations and where the need is greatest. And that may look like voting, that may look like attending to budget discussions in whatever sort of legislative body is going to be setting those in your state and area. But it is probably going to involve some education for yourself and for others about state mental health policy and local mental health policy, and advocating for that. I think it's going to be a little different in every state and every community. And so it'll be important to find out how that works in your community specifically.
Wonderful. Andrea, Dr. Avila, thank you so much for very thorough from top to bottom and engaging talk with the polls, getting everybody's known interest and awareness of this overall issue. Very much appreciated.
I appreciate everyone's participation. It was wonderful to see the polls actually being responded to. So thanks everyone for that.
Absolutely. And that wraps up this week's University of New Mexico Law and Mental Health series. Stay tuned next week for Dr. Colombino talking about adolescents who engage in sexually harmful behavior. And until that next time, have a fantastic rest of the week and take care.